This is Bankruptcy On Tape with the UCC's latest objection. The Official Committee of Unsecured Creditors of the above-captioned debtors and debtors in possession, by and through its counsel, respectively submits this objection to the debtor's motion seeking an entry of an order authorizing the debtors to enter into witness cooperation agreements with certain current and former employees, authorizing reimbursement of past and future out-of-pocket expenses of cooperating witnesses, including attorney's fees, and granting related relief. Filed under docket 2147, and states as follows. Preliminary statement. The motion seeks authorization for the debtors to reimburse to-be-named employees up to $3 million in past legal expenses in the aggregate and $240,000 per employee in future legal expenses to act as cooperating witnesses in ongoing criminal and regulatory proceedings. While the committee does not wish to minimize the burden to innocent employees who want to retain separate counsel to represent them, it is also aware that thousands of the debtors' creditors who want to retain separate counsel to press their own claims face similar hardship. It is improper to prospectively elevate requests for reimbursement of certain preferred parties. The debtors, however, assert that their requested relief is ordinary or otherwise justified by their business judgment, but the debtors cite no authority for this relief, nor have the debtors offered any evidence to meet their burden. The motion should be denied for four primary reasons. First, the debtors argue that the payments contemplated by the motion are ordinary course activities under Section 363C of the Bankruptcy Code. The debtors' argument that it is ordinary for non-operating cryptocurrency exchange to pay millions of dollars to fund its current and former employees' legal fees and expenses as part of criminal and other investigations by multiple federal and state authorities is not credible. Moreover, no creditor would have expected that their cryptocurrency would fund these types of expenses when transferring their assets to the debtors pre-petition. Second, the relief requested in the motion is unnecessary, as the Bankruptcy Code already provides ample means by which employees can seek reimbursement of their legal expenses. As the debtors acknowledge, certain potentially eligible employees are parties to pre-petition indemnification agreements, which would permit such employees to assert pre-petition claims for indemnification of legal costs and expenses through the claims reconciliation process. The debtors also acknowledge that employees who do not have pre-petition indemnification claims can file administrative expense claims or alternatively substantial contribution claims. Circumventing these statutory processes is not necessary. Third, even if the business judgment rule is applied here, the debtors have failed to meet it. The debtors bear the burden of demonstrating by a preponderance of the evidence that the requested relief is a sound exercise of their business judgment. The motion fails to provide a factual record on which this court could make that evaluation, much less evidence to support it. For example, the debtors assert that, given the aim of these Chapter 11 cases to reorganize the debtor's business and emerge from bankruptcy as an efficient and compliant business, these proceedings, the investigations, and the respective cooperation of the employees are crucial in preserving the value of the debtors' estates. But the debtors do not identify, 1, the employees whose cooperation they view as crucial, 2, the investigations with which those employees are cooperating, 3, why each employee's cooperation is important to those investigations, and 4, how the involvement of a potential cooperating witness in any such investigations would benefit the debtor's restructuring process. Indeed, many of the employees who presumably will seek reimbursement no longer work for the debtors and, apart from providing testimony to law enforcement, are no longer contributing to their reorganization. These facts would be adduced with supporting evidence in the claims process and substantial contribution process. But rather than allow those processes to play out, the debtors ask the court to accept on faith that all cooperation by all employees and all investigations is crucial to their restructuring and therefore qualifies for reimbursement at 100 cents on the dollar. The court should reject these assertions absent an appropriate evidentiary record. Fourth, even were the court inclined to allow the debtors to fully reimburse their current and former employees' legal expenses, and it should not, the court should not allow the debtors to make such payments while investigations into the debtors' pre-petition activities remain pending and results have not been disclosed, unless the committee otherwise consents. Indeed, the debtors recognize that it would not be appropriate to reimburse the individuals who the committee has identified as potential defendants in post-emergence litigation. But it is entirely possible, if not likely, that the ongoing investigations by state and federal authorities, who have significantly greater investigative power and legal tools at their disposal than the committee, will reveal that additional employees bear responsibility for the debtor's plight. If the debtors make payments to those employees, it will be challenging for the debtors or a successor, such as the litigation trustee, to later recover them, since those payments will either be passed on to those employees' attorneys or otherwise dissipated by the employees themselves. Creditors should not have to bear that risk of loss. Many of the debtors' creditors who have significant sums tied up with the debtors have proceeded pro se due to their inability to fund the cost of counsel. While the committee is a fiduciary for all unsecured creditors, it does not and cannot provide individual representation to creditors on their specific issues. Similarly, the debtors argue that their counsel cannot represent the individual interests of current and former employees. It is simply not equitable to create a presumption that the debtors' current and former employees, including employees that may have participated in the actions that caused the debtor to file for Chapter 11 or did not take appropriate action to stop or report wrongful conduct, may have their counsel's fees paid by the debtors without making individualized showings to support an administrative claim or substantial contribution claim, while creditors cannot. For these reasons, the court should deny the motion without prejudice to revisit the issue on an individualized basis, or once the debtor's forthcoming plan is confirmed and there is greater visibility regarding the identity of the litigation trustee and operations of the litigation trust. However, if the court is inclined to grant the motion, it should require the debtors to allow the committee to propose revisions to the proposed procedures, including, without limitation, confirming that the committee shall have the right to review and approve, in its sole discretion, 1, the witnesses entitled to reimbursement, and 2, the actual reimbursements those witnesses receive, as well as to re-examine any of its conclusions regarding the propriety of 1 and 2 in light of subsequent events. To the extent that the court approves the relief requested by the debtors, the committee intends to be extremely rigorous in its review of which witnesses are entitled to receive reimbursements. The committee will not consent to reimbursements absent a compelling showing regarding, among other things, the investigations at issue and the scope and importance of the witnesses' cooperation in those investigations and the debtor's restructuring. These procedures will protect the rights of creditors while also allowing employees to file pre-petition, administrative or substantial contribution claims if they believe the committee has wrongly denied their reimbursement requests.